Shall we start, Betty?
Judge Hussain, we are 51 people. I
Okay.
don't know whether you want to give another 2 minutes.
Yeah. Quite happy to do that. Can you see the the PowerPoint, Betty?
I see you and the PowerPoint. Sound is 100%.
All right.
Judge Hussain,
Yeah.
let's start.
Okay. All right. Good morning, everyone. We still faced with the load shedding, but as I told you, we'll mitigate it by running these recordings again. The other thing is, I'd like you to give Betty some feedback. I was thinking that we should run these webinars not from 11 o'clock, but from 2 o'clock. That gives attorneys and advocates a chance. If they're in court for some reason, they can finish in court and then come and log into the webinar. I think it would be more convenient. It's no inconvenience for me to start at 2 o'clock. So if you prefer it, just let Betty know, and we can adjust the times in future. There are a number of webinars coming up which you might find useful, and we'll be quite happy to accommodate you as far as the time is concerned. Okay, we started yesterday with what I think is an extremely important step, and that is the pre-trial conference. I also told you that the lawyers don't seem to take it very seriously. Uh, it became just one of those processes that you have to comply with in order to be trial certified and in order to get a judge. Well, that's the wrong attitude. Use the pre-trial conference to your advantage, and you are obliged as a practitioner and an officer of the court to make the hearing that you will ultimately go to a lot more efficient, less time consuming, and cheaper. I told you that one of the things that that reduces court time, two things. The one is to confine the issue. And number two, in respect of those issues, you must make admissions of fact which are not material to the dispute itself. That reduces court time, and that's what judges want. Now, another thing that caused a great deal that consumed a lot of court time and created huge costs are experts. Experts can take up a lot of court time. Leading them, cross-examining them can take hours. Also, experts, you must know, um, they might testify for an hour or two, but they charge you for the day. Most experts have a court fee or a daily fee that they will charge you, and it could be anything from 20,000 to 50,000 rand. That's a lot of money. Also, if you are running this on a contingency, your firm may have to put up that money. Although I must say, recently I've come across experts who take on assignments from attorneys on a contingency basis, and that's not a bad development. So you should bear that in mind the next time you're looking for an expert. Check if they will do the work on a contingency. That's of course if your firm is on a contingency. Now, one thing we know, and judges have worked this out, that when you call experts from the same discipline, for example, two orthopedic surgeons, one on each side, two neurosurgeons, one on each side, a mechanical engineer, one on each side, or a chemical engineer. Um, these are people who have studied the same degree. They have the same qualifications. How likely are they to disagree with each other? Hardly. Now, we know for a fact that the experts tend to disagree with one another only because they are instructed with different sets of facts. That's what separates them. And who gives them these facts? It's the attorneys. It's the lawyers who present the facts to the expert. Sometimes the expert will make his own investigations, like with medical matters, or an engineer goes to a construction site, will gather their own evidence. But you send two equally qualified engineers to the same construction site, they are not going to disagree with each other. So how did we solve this problem? Johannesburg, that's the Gauteng local division, was the first to do this. Many years ago, I would say it was in the 80s already. What the judges did is that they put out a directive that you may not call an expert unless you unless the experts from both sides have met and filed a joint minute. Now, the plan was to get the experts to meet and reach common ground. Well, the plan didn't work. And here's the funny part. The plan didn't work because we discovered that the attorneys were going to these meetings. Now, once an attorney turns up at the meeting with the experts, there'll be attorneys on both sides. Guess what happens? Nothing gets agreed because the attorneys will forever come up with their usual nonsense without prejudice. Everything is without prejudice. We will not make an admission. So that nonsense started. It didn't work. Then we found a solution. The solution, and that's the same situation today. The experts must meet, but in the absence of the attorneys. We don't want the attorneys there. Guess what happened? Suddenly, the experts started agreeing with each other. We just removed the attorneys. So we found that it really works. Usually, and I would say as much as 8 out of 10 cases, there's no need to call the expert. You would have filed your notices in terms of the rules. You would have filed the expert summaries. All that you will require is the summaries and the joint minute. And you will find that the two experts are not far apart at all. So there's no need to hear oral evidence from them. You save the time, you save the costs. If the experts disagree, they are required to confine the dispute to a narrow point. So, and you will never have a situation where two experts belonging to the same discipline will disagree on everything. That's not going to happen. There will be disagreements in certain cases. For example, if there's a dispute around say an aircraft crashed. So you've got engineers on both sides. They could disagree on the cause of the crash. Now, if that's the case, they must confine their evidence to that narrow dispute so that the summaries and the joint minutes get handed up to the judge, and the judge will then hear oral evidence on the one point of disagreement. That is how it's done. And if you do that, you will save court time and you'll save your clients a lot of money. Okay. Now, also, look at the facts that the opposite expert was provided. Those facts might have come from the attorney. And of course, the lawyers will provide facts on the basis that these facts will provide them with the outcome that they want. In other words, it's not unusual for the lawyers to manipulate the facts so that the expert gives them the opinion that they are looking for. That's a dangerous thing to do. Don't do it because you get found out. Because inevitably, when the expert is testifying, a good cross-examiner will say, Mr. Expert, let's change the facts slightly. If these are the facts, what would your opinion be? Would you change the opinion? Now, obviously, a good expert will make the concession and say, yes, I change my opinion. And the set of facts that got put in cross-examination will be your opponent's facts. So you see, you've got nowhere. And the judge might pick this up and you'll be in trouble. You might have to explain, where did that expert get those facts from? And why were they manipulated? So just be careful. So in the pre-trial conference, reach agreement on the experts meeting and filing a joint minute. Look, you don't need an agreement as such. It is, in fact, in the directives. It's got to be done. And I think all the high courts now adopted it. In the past, it was mostly Gauteng, and then the Western Cape followed, and then KwaZulu. But now all the courts will not give you a judge if the joint minutes are not filed. I know in KwaZulu, for example, and in the Western Cape, where they use a fixed roll, you apply for a trial date, you have to file the minutes of the pre-trial conference, and you must file the minutes of the experts, the joint minute. Otherwise, the registrar will refuse to give you a trial date. Okay. I told you, before you attend a pre-trial conference or a case conference, prepare an agenda. Apply your mind to what you need from the meeting. Now, what will help you with the basics is to look at the Gauteng practice manual under pre-trial conference, and you will see an agenda ready-made for you. I told you there were 13 points on it. You can copy and paste it and turn it into an agenda. But for heaven's sake, make sure you comply or your opponent complies with each of those requirements, okay? It's not there for you to pay lip service. But the idea is for you to send the agenda to your opponent, ask them to agree to the agenda, ask them to present their items, and then you'll agree on an agenda. When you get to the conference or the meeting with your opponents, the first order of business is to agree on the agenda. So you will have the draft. You can adjust it, you can remove a few items, you can add new items, and it shouldn't take more than 10 minutes to finalize the agenda. Now, once that is done, then deal with the agenda and stick to it. Don't get irrelevant. It is not an opportunity for you to showcase your work or to grandstand. Just don't do that. Now, you will from time to time have to attend a case conference with the judge. This is maybe a case management conference. It doesn't necessarily have to be the equivalent of a pre-trial conference. The idea is to hold case conferences with the judge so that the parties can cooperate with one another and receive direction in order to get the matter to trial quickly and finish it cheaply. Now, a good technique is for you to prepare an agenda for that meeting with the judge. Swap with your opponent. Between you and your opponent, you agree on the agenda. When the meeting is referred to the judge for a date and a time, you must present the agenda to the judge. The judge may then add an item to the agenda or may not, but the judge needs to know what is it that you want to discuss. Then, my suggestion, and this really works well, is that before you go to the judge, you and your opponent must meet and try and resolve as many agenda items as you can between yourselves, and leave maybe that one item or two items that will require input from the judge. So the idea is for you to cooperate with your opponent. If you don't, you are just going to be embarrassed at the meeting. Somebody will say, but judge, we asked for this, they refused to cooperate. And it just looks bad, okay? And finally, when it comes to pre-trial conferences and case conferences, you must keep accurate minutes. You know, it came as a surprise to me when I saw at the roll call here in Johannesburg, Judge Mojapelo was calling the roll. And if you knew him, he was not an easy judge. He was quite difficult. So he called a matter, and then he raised something that he read from the pre-trial minutes, the minutes of the pre-trial conference, which was in the court file. One of the counsel in the matter stood up and said, well, my lord, that's not what we said. The other counsel, his opponent, got up on his feet and said, my lord, That is exactly what they said. The other one said, no, we didn't, my lord. The other one said, yes, you did. And they were like two schoolboys. Didn't. What do you think Mojapelo did? He looked at these two and he struck the matter off the roll and told them to go and sort themselves out. Now, that was a disaster because they probably waited 2 years for the trial date. And now they got struck off the roll over something stupid like this. Okay. So make sure that the minutes are kept, they are made available to all the parties. Everyone must agree and they must sign it. No disputes. My advice to you is that if it's a complex case or a pre-trial where the agenda is quite big, I recommend that you record the conference. And I'm not suggesting you do this secretly, like with a microphone in your button. We don't do that. What you want to do is arrive at the conference with a digital recorder. Those things are quite small. You can put it on the middle of the table, and you must agree with your opponent to record the conference. The reason you record, you switch on recording. Now, obviously, so if there's a dispute, you can play it back, but there's nothing like switching on a recorder to get the lawyers to stop bullshitting. They will stick to the agenda, they will be relevant, they'll do the work, and they'll leave. If there's no recording, there are those lawyers who will talk rubbish. They'll grandstand and they'll show off and do all of those things. So use a recording. Also these days, a good digital recorder, recording instrument, it doesn't cost a lot of money, but if you buy one with Dragon software on it, you can almost instantly get a transcript. It's as convenient and cheap as that. Okay, now we move on to the next phase, what we call the post-certification phase. In other words, you've got the benefit of a pre-trial conference, you've got the discovery, and you are getting ready to go into court. Here are 5 things that you must do. Firstly, look at the main issues as agreed between the parties. Now things are more clear. Initially, you had particulars of claim and you had a plea, which raised a number of issues. Since the discovery, since the pre-trial conferences, the parties have now limited the issue to maybe 1 or 2 issues. That's now recorded. Now you have to review your case concept and chronology document. What you're faced with now is an issue. You know that you will have to prove certain facts in order to discharge the onus. So your case concept, which you started with before you issued the summons, will now have to be amended. You'll have to modify it because you are now going to court with a well-defined issue, and you need to ensure that your client's version of what happened will result in a persuasive version where the judge will accept your client's version and your client will discharge the onus. You will also adjust your chronology documents. You will have a chronology document that you started right at the beginning. That document can now be limited around the central issue. Then you have to carry out a fact analysis. Look at the evidence that you've got. Who's my witnesses? What will each witness say? You have to conduct what we call a proof analysis. So you look at the issue, you ask yourself, based on my cause of action or my defense, what are the material facts that I have to prove in order to discharge the onus? Make a note of those facts. Make a list. Now apply your mind to what evidence will I present in order to provide proof of those facts? Because it's your job to provide proof of the facts so that the judge can make a finding of fact. So you conduct a proof analysis. You have 4 witnesses. What will each one say? Well, 2 of them are now irrelevant to the issue. You take them off your list. Now you've got 2 witnesses. You need to work out what they're going to say. Do they support your client's version? Very importantly, will they present sufficient evidence to enable you to discharge the onus? You also need to do the witness analysis. So you take each witness. Remember, by now, if you're a good lawyer, that you will have a statement from that witness in a chronological sequence, and you'll have a chronology document that you prepared for the witness. Look at these 2 documents and see if you can satisfy the requirements of the cause of action or defense through the mouth of this witness. Which facts will this witness assist you to prove? What documents can you introduce through this witness? What documents do you need to provide proof? Those documents will be in your bundle that you agreed at the pre-trial conference. Now, those are the steps that you'll have to take. And you do this as soon as you've completed the pre-trial conferences and case conferences. You are now basically getting ready for trial. And I made a note, at all times, you are to apply your mind to a possible settlement. You can still settle a matter at that stage. And if you can't settle the whole matter, you can still settle one or more issues. Now, let me just warn you about something. Our courts do not allow door settlements anymore. You know what a door settlement is? It's where you come to court and you settle at the door. We were champions of doing that. I did it, okay? But the courts and the members of the public have found out that we were scamming them. And let's face it, we were scamming our own clients and we were scamming the public. We were scamming the judges. I can tell you, in 40 years of litigation, I have never come across a case which we settled at the door where we didn't know that it was going to be settled months before. In fact, at the pre-trial conference, you already know that the parties are going to settle. But what's on the agenda? The parties discussed settlement. There was no possibility for a settlement. But at that stage, they know it's going to be settled. So why did the lawyers settle at the door? Easy. If you settled at the door, you can say to the judge, "My Lord, we just settled." The judge will then make an order of court and you'll go home very happy, because if you settled at the door, you can claim preparation fees. And secondly, you can claim a trial fee. It's a ripoff. You never prepared because you knew it's going to be settled. And you get a trial fee, but you know you are never going to hold a trial. There's no trial. So you just used it as a billing exercise. Well, I'll tell you what put a stop to it. There was a case, and it's a reported decision. And I suggest you read it. Um, it's a judgment of Kathy Satchwell J. Now, she used to be an attorney. She was also very smart. And what happened is that the advocates and attorneys arrived in court. You know what happens in Johannesburg? You go to roll call. You tell the judge you're ready for trial. Fantastic. The judge said, I allocate you to your matter to my sister Satchwell. Right. These lawyers, as is usual, had settled the matter already. They had the order, or rather the agreement of settlement and a draft order signed already in their bags. So then these the whole team troop up to Judge Satchwell's chambers, and there they meet her and they pull the usual story. Judge, we just settled the matter. Now, usually the judges, they are very happy, very great. You settled, very nice. Give me the order. And they get the court file. It's all done in chambers, finished. But Kathy Satchwell did the right thing. She looked at the agreement, and it was quite obvious that that agreement had been signed sometimes before the trial date. Because she asked them and said, listen, how did an agreement of settlement miraculously appear in your bags from roll call to my chambers? Well, they had to admit it was signed before. Now go and read the judgment. What the judge did is that she disallowed their costs. She reported them to the Law Society and the Bar Council. She disallowed the costs of all the experts. Oh, by the way, the experts were in on the scam as well, because they put in their trial fees too. And I mean, it was like a feeding trough, you know. Well, everyone got into trouble. Unfortunately, part of that judgment was set aside on appeal on a technicality. So it's Malachi's case, Malachi versus, I think it's the Road Accident Fund. So it got set aside only on the basis that she made an adverse cost order against an attorney without hearing his side of the story. And I think that was the state attorney or somebody. Anyway, so on that basis, it was set aside. But in principle, you can't do that, door settlement. So what we've done now, we've got Rule 41, and there's a directive that says if you settle at the door, you must be prepared to explain to the judge why you settled at the door. There must be compelling reasons why you settled at the door. Otherwise, the judge must disallow your costs. Your preparation fee, your trial fee must be disallowed. So just be warned. Don't try pulling that trick again. Now, let's move towards the trial. By now, you've got a good idea of what the issues are. You must have written it down. And you must present it to the trial judge in your opening statement. Now, let me tell you something quite funny. When we started case management, it started again in this province, in Gauteng. Gauteng is always the leader. The rest of the country follows. It's because we have the busiest role in the country. What happened is that we started a case management court. It since has not been very effective. I don't understand why. In that case management court, the judges or the registrar prepared a form. It was a 2-page form in which various items were dealt with, things like, have the parties completed discovery? Yes. Are you calling experts? Have the experts met? Did you file the joint minute? So what this form did is that it had all of those items on it, which tells the judge, the case managing judge, that you're ready for trial. And then the judge will say, you can be certified trial ready, and then the registrar will give you a date. That's how it's supposed to work. There was one item on that form which was creating mayhem among the attorneys and advocates. The form said, please state the tribal issues between the parties. So the lawyers were very clever. You know what they did? They wrote C pleadings. Now, the whole reason for that paragraph to be there is because the pleadings were useless. It didn't tell the judge what the issues were. So they amended the form. Now the form read, state the tribal issues between the parties without reference to the pleadings. You know, that was the hardest thing for the lawyers to fill in because they never apply their minds to the actual issues between them. So now we force them to sit down together, work out what is the issue, and then write it down. Now this becomes helpful to the trial judge. So make sure you know what the issue is. Your case concept. That evolves from the point when you took your first instructions all the way to the trial. Are the issues as defined compatible with your case concept? Can you, on the facts of your case, say that the issues represent what happened between the parties and that your client's version will persuade the judge to decide those issues in your favor? In other words, you will be able, on the evidence available, to discharge the onus on a balance of probabilities. Look at the legal requirements to establish your claim or defense. Now, by now, you're an absolute expert on the facts. You've got all the facts. You know the facts. They're on your fingertips. You're really good at it. So the factual part you have mastered. Now look at the legal requirements. Okay. What are the facts that support or prove those requirements? Now remember, in any trial, the judge is called upon to make findings of fact and law. Logically, a judge cannot make findings of law until he's first made the findings of fact. So the judge makes findings of fact and then applies the facts to the law. What this means is that any legal submissions you make to the judge must be supported by the facts. If it is not supported by the facts, the judge is not going to be persuaded by it. So be very careful about that. Your fact analysis will look like this now. Make a note, and I say write it down. What are the material facts you need to prove, bearing in mind the issue, the onus, to succeed in discharging the onus? Now, this is how you do it. Write the material facts that are undisputed or admitted, or where your opponent will have no basis for disputing them. Now, that's a very important list. Look at it. The facts that are undisputed, the facts that are admitted. Now, the two are not the same. Undisputed means that the parties have no problem with it. It can be admitted. It's like common cause facts. Admitted means those are facts which at some point during the process was denied, but now they are admitted. So they go on into the undisputed side of the column. And also write down those facts which your opponent refused to admit, but you know they have no basis in fact for the refusal to admit, or they have no basis in fact for denying them. Now, the reason you want this list of undisputed facts is because you know that if you present those facts to the judge, it will assist the judge in determining the probabilities of the disputed version. So when the judge has to resolve the dispute, the judge will be looking at the undisputed facts and say, the, the plaintiff's version on the dispute will be more probable if it is supported by the undisputed facts. The judge will test your opponent's version in the same way. If these are the undisputed facts, how likely is the defendant's version to have happened? Now, I told you, adversarial court, not looking for the truth, looking for what is likely to have happened. As judges and as lawyers, we can work out the probabilities, but we will never know the truth. You don't need to know the truth. You just need to be satisfied that that version is probable. That is what is meant by proof on a balance of probabilities. It's not truth, it's proof to the balance of probabilities. So again, I'm going to repeat, if you go to court with a rubbish version, it will not be compatible with the undisputed facts. The judge will find it to be improbable and you will lose the case. You'll be the dirty dog, okay? Now write down the disputed facts that you have to prove. Now you're at a trial. There's an issue. There's a factual dispute and there's a legal dispute. Judge must first resolve the factual dispute. You have to assist the judge in doing so. You know, when you present the judge with the undisputed facts, you are helping the judge by saying, look, in order to make a finding of fact, you have to consider these undisputed facts. They will help you to determine the probabilities. Now what you have to do, having identified the disputed facts, you have to make a list of the witnesses you need to provide proof of those facts. You will also look at the documents you need, contemporaneous documents, visual evidence. What will you need to provide proof of those facts? You will then have a list of facts which support your version, okay? You also need to make a list of those facts that don't support your version. In other words, they support your opponent's version. Make a list of the undisputed facts that support your version. I've dealt with that. Now, what do you do with the bad facts? Those facts that don't support your version but support your opponent's version. As a good lawyer, in preparing, you will try and find a means to undermine those facts. You can do that by showing that your opponent's version is improbable, and therefore we can't believe anything he's saying. Or if his version is likely to have happened, then look at the details and then say if that detail is not likely to have happened. The third way of dealing with it is to prepare good cross-examination of your opponent's witnesses on those bad facts. Try and undermine them in cross-examination. And please remember, when you cross-examine your opponent's witness, in order to undermine their strong facts, never, ever use anything other than a leading question. I'll say more about that later. And here you've got a witness analysis. You're going to look at the lists that you made. You have a list of witnesses. Work out who will provide the evidence to present your client's version. Of course, your client may be one of the witnesses. make a list of the witnesses. And how it's done, it sounds like a lot of extra work, but it's worth doing. Put the name of the witness, John Smith. Now write down, just in a shorthand, the main facts that he's going to testify to. I'll tell you why you do that, for two reasons. First of all, when you do that exercise, you are applying your mind now. You're forcing your mind to think, why is this a material fact? Why do I need it? At what point will I introduce it into evidence? That comes into your head. So you are preparing very well. The second advantage of doing that is when you go to trial, you will have that list in front of you. You will know immediately that I have to call John Smith as my first witness. I know what he's going to say. I will also have his chronology document next to me. Good lawyer, you will do very well. The next question is, take an overview of the witnesses you have, and then ask this question: will the evidence be sufficient? It's what we call the sufficiency of evidence. In other words, will it be enough to discharge the onus? Will it be enough to provide proof of the material facts for the judge? If you conclude that it's not enough, then there's obviously a gap in the evidence. You'll have to take instructions. You'll have to find the evidence. Okay. Now, if you didn't do this exercise, the danger is that you'll be in the courtroom and then the gap will hit you. You'll think, oh gosh, there's a gap in the evidence. Now you're scrambling for a witness. Now you want to tell the judge to stand the matter down while you go off hunting for a witness. You may even have to ask for a postponement. And if it gets refused, you're in trouble. Okay, so be very careful of that. Now do the sensible thing. Establish with client if the witnesses are still available and willing to come to court without a subpoena. You know what? Forcing a witness to come to court to testify for you is a dangerous thing. They really don't want to help you, and they might dig a hole for you. Be careful. One of the reasons, a very popular, well, I shouldn't call it popular, a reason that comes up all the time in court for postponements, for standing downs, is because the witness didn't turn up. I mean, without the witness, what are you going to do? You can't run the trial. You'll fail to discharge your onus. Now, the trick is to identify witnesses at an early stage before you issue the summons. I told you, take a written statement signed by the witness. Now keep a track on them. Get someone to call them regularly. Find out how they are. Are they still living at the same address? Are they still working in the same place? Do they still have the same cell phone number? Things like that. So that when it comes closer to the hearing, you'll call them and say, look, you are expected in court on this day. Will you require a letter for your employer? Something like that. Or I'll get a subpoena, which you can hand to your lawyer, to your employer. You see, you have to assist witnesses to come. You may have to send a cart to fetch them. They may not have transport. You may have to arrange parking. And if you're appearing in Johannesburg, you may have to arrange security because everyone could get bloody robbed on the street outside. So now, for each witness, a statement from the witness which you took down in a chronological sequence. You must have that. You must have a chronology document for each witness. What do you do with that? You will use it to lead your witness in chief. One thing you shouldn't do, it's a bad technique. Don't try and lead a witness from the statement that they made. It's a busy document, and you don't want to be stuck to a document. When you lead a witness in chief, it's very important for you to maintain eye contact with the witness and eye contact with the judge. You don't want to be standing there like this while the witness is talking and the judge is writing and you carry on. I mean, it is not persuasive. It looks like you are unprepared. It looks like you're not interested in the case. It creates a bad impression. You stand upright, facing the judge, facing the witness. Your eyes meet with the witness. You're looking at the judge. You pace yourself. You use your voice, your tone. The witness says something important. You know, don't move on to the next question. So, for example, the witness says, I saw the defendant drive through a red robot. You will go, oh, Mr. Jones, that's an important fact. I'm sure his lordship would like to hear more about that. What was the color of the robot? It was red, my lord. And now you look at the judge with a telling expression. Now you're being a good lawyer. You don't want to stand there and drone in a boring monotone and look disinterested. You know what? Judges get disinterested too. They'll stop listening to you and your witness. So be careful about that. A chronology document helps in two ways. Firstly, you can hand up the document to the judge and say, my lord, I have prepared a chronology document for this witness. Judge has got it. And now you lead the witness from the chronology document. How it helps you is that you don't have to be reading the statement. All the main points are there. Easy to find. All you need is to keep the chronology document on the desk in front of you, and you don't have to even hold it in your hand, and you can lead the witness. Works brilliantly. You must also have a document where you write down the order in which you call the witness. Now, let me give you some advice. You always start with your best witness, with your strongest witness. For heaven's sake, don't start the trial if your main witness is not there. Now, this happens in court, okay? Murphy's Law. The witness will tell you they're ready, they'll be there at 9:30, and in fact, they're there. And you're very happy. You go into court and you say, my lord, I call my first witness, Mr. Jones. So the court orderly goes there and screams for Mr. Jones, but he's not there. And you say to the judge, but my lord, he was there 5 minutes ago. Well, he's not there now. What did Mr. Jones do? He decided he needs a Coca-Cola, and he's walked up to the gate outside to buy it from that lady sitting there in her little spaza shop. So now the judge looks at you and says, listen, call your next witness. Don't you have a witness that we can start with? Now, let me warn you, don't let judges nor your opponents force you to start with a witness who is available, but it's not your best witness. Don't do it. Just insist, my lord, stand the matter down. We'll send a search party to find this witness. Okay. Because if you start with a witness who is not good, does not impress the judge, right away you're on your back foot. You are at a disadvantage. So what are you going to do when you call your best witness? You're trying to practice damage control. Now, it looks like damage control, and it's not good for you, okay? And then just some rules of evidence. Always call witnesses whose evidence, firstly, must be relevant to the issues, admissible in its form, and probable in relation to the facts and circumstances of the case. That's the test. Relevant, admissible, probable. If your witness fails one of them, it's not a case of 2 out of 3 or 1 out of 3. It has to be 3 out of 3. It's like those shows on TV, you must get 3 yeses, okay? If you get 3 yeses, you can call the witness. If you don't get 3 yeses, you're out. That witness is out. You can pick one. What if the evidence is inadmissible? Useless. What if it's relevant, but it's not probable? The version is rubbish. Not going to be believed. Okay? So if you get it wrong, you're walking into an expensive debacle. That's all. Okay? And of course, make sure long before the trial date that you know which witness will require an interpreter, and make sure you book an interpreter in time. You know, it is so frustrating, and lawyers don't get this right. You're ready to start. The judge sends his clerk in to say, can we start? And you say to the clerk, the registrar, sorry, apologize to the judge. The interpreter is not here. So where is the interpreter? We don't know. We sent someone to look for him. Okay. And by the way, if you have a witness who speaks one of the rare languages, like they're from Venda, oh my God, you will never find a interpreter on the day. It's like as rare as hen's teeth. You need to book those people in advance, phone the day before the trial, phone the morning of the trial, make sure they're there. Okay. Now, I've said a lot about this already, so I'll take you through this very quickly. It is an essential technique to have a list of the undisputed facts, and also have on this list those facts that are not admitted by your opponent, but you know that they have no basis for it. Now, why do you need it? Undisputed facts are very important to your outcome. They assist you in determining the probabilities. They assist the judge to determine the probabilities. Now, I'll give you another example of how important the undisputed facts are. Most of you by now should be familiar with the Plascon test. It's in the case of Plascon Evans versus Van Riebeck Paints. It's a test which is used to resolve disputes of fact in an application. So you got 3 sets of affidavits. How do you resolve disputes of fact? If you go and read the test, you'll see it is based on the undisputed facts between the parties, number 1, and number 2, the elimination of non-meritorious denials. In other words, and bizarre or improbable versions. So if one of the parties, how it works is that you look at the applicant's facts that are admitted by the defendant, and then you look at the defendant's version, and you ask a few questions. Can we grant a final order based on those facts? If the answer is yes, give the order. Number 2, also look at the respondent's version. Is this likely to have happened? Or is it a lot of nonsense calculated to delay the applicant? Is it a version that is bizarre or non-meritorious? The defense is non-existent. Irrespective of the disputes of fact, you give an order. So you see how important these undisputed facts are. Go and read that case. Just take it from me. The judges find the undisputed facts essential in resolving the disputed facts. They help to resolve the disputed facts. How? Because they help the judge to determine the probabilities. So where there's a dispute of fact, it's the undisputed facts that help to determine which party's version is probable and therefore more persuasive. And you know, if you've got a list of undisputed facts that favor your client, It works brilliantly under cross-examination, because all you do is you put leading questions in your opponent's witness's mouth. The leading question is based on the undisputed facts, okay? Like it's undisputed that the defendant left a skid mark of 25 meters. So you do this. Mr. Jones, the accident happened in town. Yes. The speed limit is 60. Yes. It was a bright sunny day. Yes. You left a skid mark of 25 meters before the intersection. Yes. You stated in court that you were driving at less than 60 kilometers per hour. Yes. Stop right there. You've just discredited that witness using the undisputed facts. Okay? So remember to measure the probabilities of your own client's version against the framework of the undisputed fact. It doesn't make sense to spend a lot of time discrediting your opponent's witness's version when your own witness has problems with the probabilities of their version. So test your own witness as well. But I'm not suggesting that you spend too much time on the undisputed facts. Ultimately, you'll concentrate on proving your version of the disputed facts, because that's where the onus lies. Concentrate on the disputes, get the witnesses and the exhibits and the documents that support the version. If the undisputed facts don't support your client's version or your witness's version, you got a big problem. Now, witnesses are crucial. Here's a checklist, okay? I gave you this because you can use it when you're preparing for trial. Check if your witness is relevant to the issue. Is the evidence in a form that's admissible? Is the version probable in the light of the undisputed facts? So there you've got the RAP test: relevant, admissible, probable. If you don't tick all three, get rid of the witness. Can't help you. Does the witness testify from personal knowledge? Very important. Judges are persuaded by witnesses who testify from personal knowledge. Did your witness have enough opportunity to observe and make a reliable recollection, and is able to reliably tell the judge what they saw? Look if you can support your witness with contemporary documents. Very important. Will your witness need corroboration? If necessary, these are what we call credibility witnesses. You need to support your witnesses, your main witness's credibility, but it's not always the case. If your witness, and there's some advice for you, okay? If you call a witness in chief, that's your best witness, you're starting with that witness. If that witness goes really well, an absolute star, don't call the next witness. Your next witness is one that's called in support. It's just corroboration. This next witness doesn't give the judge any new evidence. You only use the supporting witness if the first witness did badly or there were some gaps in the evidence. But if your first witness turns into a star, just tell the other two witnesses to go home. Okay. Because if your first witness is a star, the next witness can only make it worse. Okay. They'll end up undermining the first witness. They'll introduce contradictions that were not there. And it just a big disaster. Okay. Check if your witnesses could be mistaken. Look for possible bias. Is there a reason this witness has to lie? Do they have an interest in the outcome of the case? You need to check that, because if you don't and your opponent finds out, they'll destroy the witness. Any motive to testify, which could possibly discredit your own witness? Is the witness's version supported by the undisputed facts? Or is the version contradicted by the undisputed facts? You see, this is a neat checklist of all the things I told you already. And here's the preparation checklist. Next checklist. Now, I'll tell you why I give you checklists. Because I found over the years that the lawyers like these checklists. I've even known many firms put these checklists on a piece of paper and they laminate it and they put it on the desk and they use it all the time. Did you do a proof analysis as I explained it? Where is the witness ranked? Now, I told you you'll have a list of witnesses, your best witness at the top. So you rank your witnesses, okay? Did you prepare a chronology document for each witness? Did you hand a copy of the chronology document to the witness and explain that you will lead accordingly? Does your witness have access to the written statement? Did your witness have time to read the statement? Were you able to select the documents you will introduce through this witness? And did you flag it in the bundle? You know, there's nothing worse than how it's done. Let's assume it's not on case lines. You will have the bundle, there'll be 4 copies of the bundle in court. You'll have a bundle of documents in front of you. The judge will have a bundle, your opponent will have a bundle, and you must make sure there's a bundle in the witness box. Now, you know you're calling Mr. Jones. You know that you'll start with page 6 of the bundle. Go and open the bundle to page 6 and have it open and ready for the witness. So, and then flag the other documents that you will need. Use a pink sticker or something, and you'll tell Mr. Jones, turn to the next page marked with the pink sticker, and it goes quite smoothly. What you don't want is for the witness to be in the box, and now you're looking for the document. The witness can't find it in the bundle because he's got bundle B instead of bundle A, and it looks so unprofessional, and some judges will get irritated with you. Have you prepared a document? Do you have a thorough knowledge? Sorry, I missed a very important one. Have you been through witness briefing? Here is something that South African lawyers somehow overlook, and it is so important. What is witness briefing? Witnesses are not lawyers, they're lay people. They don't know what happens in court. Also, I would say 9 out of 10 witnesses you call will be nervous. They'll be nervous about appearing in court. Lay people think that if you go to court, then you're definitely in trouble. Someone has to explain to them that's not the case. But the most important thing is, either the day before the trial or early the morning of the trial, you must, either you or the attorney or the attorney's candidate or a paralegal who is trained to do this must give the witness a briefing. In other words, explain to the witness how the process works. Take the witness into court. Show them the layout. Let them walk around. Get them to stand in the witness box. Explain how to stand, which way to face, how to address the judge. Explain that this thing is a microphone. It will record you. Explain all the role players, the lawyers, the judge, the interpreter, the stenographer. Explain all of those things. Because this witness, especially your first witness, will not have the benefit of seeing the other witnesses perform. So show them the place, tell them what to do, explain how their name will be called at the door. They will walk in, where to walk, and so on. Witness briefing is important for one reason, and that is it mitigates anxiety and nervousness. Um, if people know what's going to happen, they've been there, they've seen it, they'll be less nervous. You will not eliminate nervousness. Courtrooms are not friendly places, so don't expect them to be completely relaxed. The only witness that will be completely relaxed is the one you will encounter in the criminal courts, who has a record as long as your arm. They will give you a briefing. But, in your civil cases, those witnesses don't know the courtroom, and this will be the first time they appear. Carry out witness briefing. By the way, those countries that use jury trials, those lawyers have made it compulsory to carry out witness briefing. Because if the witness is nervous and doesn't perform well, juries are not impressed. They will say, this person is lying. It's not the case with a judge. The judges are trained lawyers. They will know that this witness is nervous and not a liar. But a jury, there's a hairdresser sitting in the jury. They don't like the look of this witness. So they're going to find that they're a liar. That kind of nonsense goes on. But you need witness briefing. Please, if you're in an important trial, never miss out on witness briefing. Take the time to do it. Those of you who are in big firms, you do a lot of litigation, train someone in the office to do it, and uh, take the witnesses to court early in the morning or the day before. Give them a tour of the court and explain what happens. In the United States, where they have jury trials, in their big trials, they have these massive damages claims there. They're highly litigious, those people. They don't just do witness briefing. In an important case, they will simulate a courtroom in their office, and they'll put the witness through a whole trial, simulated trial, so they will know what to do in the trial itself. That's the extreme to which they will go. Well, you must also have a thorough knowledge of the available facts and know where the witness fits into your case concept. And you will, of course, rank the witness accordingly. You have prepared a document with the main facts for the witness. I mentioned that document, arranged in a sequence, and you can use it as quick reference. By the way, you should have a chronology document which deals with the main events of the case in a sequence, with the dates. And that would be the chronology document for the trial, and you will hand that to the judge in opening statement. So make sure you have that. You must be satisfied that the evidence you will lead will not fall foul of the rules of evidence. It must be relevant, admissible, and probable. Here we go again. Okay. Now here's a warning. Never overtry a case. Don't be tempted. What does it mean to overtry a case? Overtrying a case is where you call more witnesses than you need. What you want in court is that for each material fact that you have to prove, you only need one credible witness. If you call the next witness who will give the judge the same facts, and a third witness who will give the judge the same facts, you are going to irritate the judge. That's called overtrying a case. And I told you there's a danger in it. You are now creating scope for cross-examination. Keep it short, or you run the risk of irritating the judge. The judges hate long trials. If you made the point, you don't need to call another witness. I've dealt with witness briefing. You have to do it. Please do it. Now, heads of argument. This is crucial for you. I know it's a lot of work, but it's worth it. and you're a trial lawyer. So there's no such thing as too much work. You know how to work through the night, okay? You know, you must be like a police officer. Police officers always work day and night to catch a criminal. Actually, what happened is that the people brought the criminal to the police station, and that's how they work day and night. Okay. Well, trial lawyers don't keep office hours. Just get that straight. From now on, just take it that a good set of heads of argument is indispensable. Absolutely indispensable. Now, I'm going to say something. If you quote me, I'll deny I said it. Gone are the days, and seriously, they are gone forever, it looks like, where you will appear before judges who are so experienced and capable that when you close your case in court, they give you a judgment immediately. It's what we call an extempore judgment. We had a number of judges on the bench who did that. It's an absolute pleasure. Can you imagine? You say, that's those are my submissions, my lord. You sit down, and the judge says, I will now proceed to give judgment. And out it comes. Okay, extempore. Doesn't happen anymore. What happens now, because the judges are mostly inexperienced, look, it'll take them time, but they'll eventually get there, I think. But the less experienced judges don't have the skills nor the confidence to give you an extempore judgment. So what do? They reserve judgment. And that's where your heads of argument kick in. It is brilliant for you when the judge reserves judgment. Now, if you take judges in busy courts like here, they may not have the time to start writing the judgment that afternoon or evening or that weekend. They might look at it maybe in a few weeks down the road. They don't have a full recollection of what happened in the case because remember, they've heard many other cases in between. What they will rely on very heavily are your heads of argument. It guides them. And you'll even find judges these days saying, can you send me an electronic version of your heads of argument in Word format? Why do they do that? Because they need to copy and paste from your heads. Okay. Not advisable, but that's the reality. Okay. Also, they can copy and paste references from your heads. Makes life easier for the judges. That's a big advantage, heads of argument. But there are other advantages. You know, at this stage, your case concept is clear to you. You know what the issues are. You know where the onus lies. You know who the witnesses are and what they will say. I recommend that you start drafting your heads now. In other words, before you go to court, weeks before you go to court. The advantage of that, it represents the best opportunity you have to prepare for trial. I can assure you, try it. I can absolutely assure you that when you write heads of argument, it forces you to apply your mind. Okay, thinking about a case, yeah, I know what it's about. It's brilliant. I can succeed. I know what the witnesses will say. Try and write that down. And it opens up a new world for you. You start thinking. You will start thinking, what is the material fact from this witness? Is this admissible? Okay. Is this a probable version? You'll ask those questions. Okay. Why is this case helpful? What is the ratio? Which is the paragraph that I need to rely on? You will only do that if you write heads. Now, you will have a set of heads. In fact, you will run your trial according to the heads that you drafted. And obviously, you cannot anticipate exactly what the witnesses will do. So you'll amend your heads after the witnesses testify. You can do it in minutes. You've got your laptop there. You've got the heads on it. You just adjust the paragraph that you need to. And remember, keep the heads short, sharp, to the point. Lengthy heads don't work. Do not give the judge 40 pages of heads. They hate it, okay? Just don't do it. Now, I have to say something about virtual hearings. They're still around. Last week, I argued a matter virtually, and on Monday, I'll be arguing an application here in Johannesburg from where I'm sitting right now. I love it because it means I don't have to go to Pritchard Street and wear my gumboots while I walk across all the feces that's there to get into court. Okay, so it's very nice. And so this kind of hearing is obviously well suited to applications, reviews, and appeals. But they are being used for civil trials as well. Look, many of our courts have gone to in-person hearings. For instance, the SCA in May of this year already put out a directive that they will no longer entertain virtual hearings. You come to Bloemfontein, okay? But you never know. That can be reversed. All we need is a new variant of this virus, and we'll all be doing everything virtually again. Now, with virtual hearings, the best advice I can give you is to prepare excellent papers. Not good papers, but excellent papers. You need excellent pleadings, excellent affidavits. The reason being is that one of the things you lose in a virtual hearing is this personal contact with the judge, and the ability to sway the judge is diminished. I'm not saying you must be less eloquent. You can be just as eloquent as ever, but there's a disadvantage. There's also a huge disadvantage in the sense that as lawyers, we do perform better on our feet. Like I find myself, I'm way better on my feet than when I'm sitting as I am now talking to you. So why do you need excellent papers? It's because with virtual hearings, the judges are compelled to read the papers before the hearing because they know what the disadvantages of a virtual hearing are. So they will rely on their papers. They would have read the papers. They would have read your pleadings or your affidavits. They would have read your heads. If you wrote bad papers, you are in trouble, okay? Your pleadings and affidavits must disclose a sound cause of action and must be supported by a version that is probable. That's it, okay? Now, I'm going to recommend that you get my new book. I know many of you have it already. It's called Trial Advocacy, The Art of Persuasion. This book is a comprehensive treatment of everything you need to know to be a good trial lawyer. Okay, now we move to the trial itself. And again, there's the usual reminder. You must still attempt to settle. Now, if you are in outside of Johannesburg, or outside of Gauteng rather, though all the courts use a fixed roll. In other words, you apply for a trial date. If you are certified trial ready and you complied with the directives, the registrar gives you a date. On that date, you will arrive in court and you are guaranteed a judge. You will be in front of Judge Smith in court 4A. You're good to go. In this province, you don't always get an advance allocation. You'll have to go to roll call, And there, the judge will then allocate depending on the availability of judges and the number of matters on the roll that are ready for trial. Um, it will be a good idea for those of you who haven't experienced this to go and sit at roll call in Johannesburg or Pretoria and experience how that works. Sometimes it's chaos. Find out where your matter has been allocated, introduce yourself to the judge, see that your first witness is present and waiting outside the court. That's the idea. Interpreter and stenographer must be present. You know the number of hours I've lost over the years because one of these two didn't pitch or was late. That's the stenographer, notorious for being late or disappearing, and the interpreter. Um, these days, I find that the interpreters are more professional, especially the ones that you book in advance and so on. They're pretty good. In the past, we had a big problem with interpreters. That was because it was hard to find a sober one. They used to turn up in court drunk as a lord. Um, we used to actually, it got so bad in some courts that we used to go to court in the morning with a flask of strong coffee. So you find the interpreter and you give him lots of strong coffee to drink just so he can start functioning. Uh, those things have disappeared now by and large. You must start on time. Judges hate it when you cause a delay. They hate it even more when they walk into court and you request the matter to stand down. Check if the bundles are available. See that there's a bundle available for the witness. The idea is to call the judge at 10 o'clock, not a minute later, and start immediately. You must check with the court, with the registrar. Some courts start at 9:30, not 10 o'clock. I'm talking of the High Court. Okay. So don't take it for granted that they start at 10. I've made that mistake. All right. Now we get to the opening statement. You're ready to go. Now, I'm just warning you, this is not a trial advocacy program, okay? But there are trial advocacy techniques that I'm going to talk to you about. And I'm going to make practical suggestions, all right? Firstly, judges hate lengthy opening statements. Most judges, when they sit down, now remember, what did the judge do before coming into court? These days, judges are trained that they must read the papers before they come into court. You know, when I was a young advocate, judges never read the papers. Not because they were lazy, they just never had the file. The judge saw the file the first time when the matter was called in court. And then, as a trial lawyer, you have to stand up and take the judge through the papers before you could start. That was a waste of time. We know that wastes time. The court is far too busy for us to do that. So we don't do that anymore. Judges read the papers. Now let's look at a trial. What do the judges read? The file, the court file for a trial is separated into two parts. The one is called the pleadings bundle, and the other is called the notices bundle. The pleadings bundle is the important one. Judges never read the notices bundle. It's a complete waste of time. Nobody reads it. They look at the pleadings bundle. What's there? It's the pleadings, the minutes of the pre-trial conference, the joint minutes of the experts. They look at practice notes, if you put them in, and heads of argument, if you submitted short heads already. Now, the judge will also look at the minutes of the pre-trial conference. Betty, there's a question from Janine. Someone put their hand up. Okay. Janine, we'll deal with your question later. Unless you want the short break, maybe I should take the short break now. Yeah, it's a convenient time. Let's take 10 minutes. Okay, get back at 10 minutes at 12:42, and then we'll carry on. And Janine, if you want, you can talk to Betty in the meantime. All right. Did you hear me, Betty?
Yes, sir.
Okay, we'll start in 10 minutes. Can we start, Betty?
We can start, Judge Hussein.
Right. Okay. All right. We're dealing with opening statement. So I started off by saying, don't make lengthy opening statements. Judges would have read the papers before coming to court. And here again, if you drafted good papers, you run it at an advantage. Let me give you an example. Let's say you're acting for the defendant and your plea comprises of a set of bare denials. So the judge reads the particulars of claim. Judge thinks, well, plaintiff has made out a cause of action. Let's see what the defendant's defense is. And what does he see? A whole lot of bare denials. The judge is already thinking this defendant has got no defense. It's an abuse of process. He's against you already. Or let's assume you drafted bad particulars of claim. They came out of a precedent. The judge is not impressed. The judge doesn't know what happened. Your pleadings don't tell him. So the prima facie view that a judge arrives at in chambers can be adverse to you. And that happens when you draft poorly. Okay, so learn to draft well. When you get on your feet, just tell the judge what the case is about. Just so the judge understands the nature of the issue, and now get to the agreed issues. What are the agreed issues? Remember, we're now in a situation where whether you are where the judge may not rely on the pleadings. If the judge will read the minutes of the pre-trial, and there the judge will see what the agreed um, uh, issues are. Just excuse me for 1 second, please. Eric, I can't go to the kitchen, go to the switchboard and switch it on. Sorry, that was the most important person in my life. The guy who services my pool. It's forever green, when I have to service it myself, it's just the shade of green that varies from week to week. Anyway, so we're in a situation where the judge will have a written document, either the case management form, and it will mostly be in the pre-trial minutes where you agreed on what the triable issue is. At this stage, hand up to the judge a chronology document you prepared for the trial. Judges find it helpful, and tell the judge what your estimation or estimated duration for the hearing is. That's something they want to know. Now, just let me warn you about duration. In those courts outside Gauteng, like Durban or Cape Town or Kimberley or Bloemfontein, those courts used a fixed roll. When you apply for a date, you have to give an estimate of how long the case will take. The registrar will allocate you a trial date for that period. If you say the trial is estimated to run 3 days, you will get 3 days. But when you get to court, you will have a judge waiting for you, and you can start immediately. If you go beyond the 3rd day, you're going to have a problem, because in a fixed roll, the judge will say, sorry, it's got to be postponed now. You'll have to arrange another date, because the judge can't go into the 4th day, because there'll be another matter allocated to that judge. Now, here's something that you must bear in mind and never forget it. Part heard cases are the worst. Don't have part heard cases. They have so many disadvantages. The idea is for you to go to court with a trial, start it and finish it. That's what you want to do. You don't want to leave it part heard because you'll come back. The next time you get a date, now remember, it's not just availability of the date. Now it's the availability of the judge. Now, judges don't sit in the same courts every term. They take turns. One term they're in criminal courts, another term they're in motion and appeals, and then in the third time round they'll be in civil trials. Now, you'll have to wait for the judge to be on civil trials, and then they're going to have to find a date to set this part heard matter down before the judge. It's just too much admin, takes too long, and it costs more. So don't have part heard cases, okay? If for some reason you know that you can't finish the case, then my advice to you is don't start it. Don't start it. Start it before another judge on another date when you know you can start and finish, okay? That's the way it's done. In Gauteng, if you use, we use the continuing roll. What that means is when a case is set down on the roll, it runs until it's finished. But it's not as simple as that. If you have a trial where your estimate is for more than 4 days, you are supposed to write to the registrar or the JP or DJP to say that this particular trial will run for 4 days or more. The reason for that is in a continuing role, judges are not always available. They are not allocated in advance. Judges will be told you are in civil trials this term. Now, the number of judges available on any particular day varies. So if you have a trial that's going to exceed 4 days, the judge president will have to allocate it to a judge who can sit continuously for more than 4 days, maybe 5 days or 6 days or even a month if it's required. Now, if you don't tell the judge president, that you are going to exceed 4 days, then there's a good chance that at the end of the 4th day, you're not prepared. Your judge will not be available on the 5th day. And you're going to end up with a part heard again, which is a disaster, okay? Now, you want to tell the judge how you intend to run the case. Give details of the witnesses and the order in which you will call them. You must deal with the logistics, or what we call housekeeping. Check if the judge has the bundles of documents, the minutes of the case conferences. Deal with any queries that the judge might have, and then call your first witness. Now, if you did the witness briefing, your witness will be impressive. The witness will walk smartly and confidently into the witness box and take the oath. No delays. It's slick. It's professional. Now you are leading the witness in chief. The first rule, never forget this. The judge wants to hear the evidence from the mouth of the witness. The judge does not want to hear from you. You will discredit your witness and the evidence if you ask leading questions. You see, if you ask leading questions, you are putting the answer in the witness's mouth. That means you are not giving the evidence. I mean, your witness is not giving the evidence. You are giving the evidence. And that's of That's not persuasive. It's of no probative value. You must keep in mind your case concept and where this witness fits in. You will have a copy of the chronology document in front of you, and you'll have a chronology document for this witness from where you will lead. You are not to read from statements. Keep eye contact with the witness and the judge. Always lead a witness in sequence. Now, you would have prepared your witness to give evidence sequentially. The narrative must be from beginning to ending, step by step. It must not be all over the place. Your questions to the witness must be short. When you get the answer you want, you move on. And when you've got the version that you want from the witness, sit down, okay? Don't get the witness to repeat the evidence. Judges hate that. It wastes time, and it certainly does not strengthen the point if you keep repeating it. The opposite happens. And then your witness will be cross-examined. Then comes re-examination. Now, the first rule of re-examination is don't re-examine. Lengthy re-examination means only one thing. It means that you and your witness is in trouble. If your witness performed well in cross-examination, there should be no re-examination. And I warned you, if your witness performed well, don't call supporting evidence. You must be all the time remain aware of your list of witnesses and your witness analysis. When you have the evidence you need, close confidently. Now, here's the problem. I've seen this mess up in courts all the time. So the third witness, or rather, let's start with the first witness. The witness has given the version. The narrative has come out. Now the lawyer is keeping quiet now, is looking at the witness and says, Mr. Smith, do you have anything else to add? And then Mr. Smith is quiet. He's thinking about it. The judge gets impatient and says, yes, any further questions? Now the lawyer looks up and says, my lord, could I have a short adjournment? Or they engage in a whispering exercise in court. You know, you lean over and ask your assistants if there's anything else and so on. It's so unprofessional. Judges hate it when you ask for short adjournments, especially in Johannesburg and Pretoria, where the judge's chambers is probably 8 floors away or even in another building. So the judge has to go all the way to his chambers, only to be told to come back. It's really irritating. Don't do it. What looks good is when your witness has, sorry, before I go there, let's say you finished your third witness and the judge says, any further witnesses? You're now not sure. So you look at your assistant and you have a whispering session, or you say to the judge, worse, I need a short adjournment. That's no good. You must know your case concept. You must know the plan. You've written your heads. When the third witness, Mr. Mokoena, has finished giving evidence and then has been cross-examined, you stand up and you confidently say, I close my case, my lord. Or that is the case for the plaintiff, and sit down. Okay? You look confident without looking smug. Okay? Judges hate it when you look smug. All right. Now, I'm going to take you to some suggestions on your technique in leading a witness in chief. I think this is important for you. Like I said, it's not trial advocacy, this. Um, we will probably next year provide you with a trial advocacy program, but it'll have to be live because it requires performance skills, and it's not something you can do virtually like this. Although we may have to do a virtual program as well, because not everyone can afford to travel to Pretoria or Johannesburg. Um, and I certainly don't enjoy traveling to Durban. So actually, I like Durban, except now it's a complete disaster. It's even worse than Joburg. If you can imagine a place worse than Johannesburg. All right. The first thing is you are not to ask leading questions. When you ask leading questions, the judge puts down the pen and says nothing and doesn't make notes because it's useless. You, the lawyer, is now giving the evidence. Now, usually when you ask leading questions, you can ask leading questions to bring out facts that are not in dispute. So, it'll take you a number of questions to bring out the witness's personal details. And your opponent does not dispute the personal details. So instead of saying, where do you live? What work do you do? And so on, non-leading questions, you can just simply ask a leading question. Mr. Mokoena, you are the purchasing manager at Checkers and you live in Bryanston. He'll say yes. Quick, easy. It's undisputed. The proper technique is to say to your opponent before you start, look here, would you mind if I led my witness on these undisputed facts? Your opponent will say, no problem. Before you ask the question, tell the judge, my lord, I will be leading this witness on certain undisputed facts, and I do so with the permission of my learned friend. Judge is happy. Now ask the leading question. When you come to the disputed facts, that's when you stop asking leading questions. And if you do ask a leading question, firstly, your opponent will object. That makes you look like an ass because now you're going to rephrase the question. And if you get that wrong, sometimes what happens is you tell the judge, I'll rephrase, my lord, and then you ask another leading question. You look like a real fool. So avoid the leading questions. But I want to show you how you can avoid it. Firstly, use simple questions, plain language, short questions, one question, one answer. That works. You know, there are those lawyers who like using big words. They sound bombastic. Well, it doesn't work. The people in the gallery will think, wow, this lawyer is so clever. I don't understand a word he's saying. Well, guess who's not understanding you too? The judge. So don't be a show off. Keep your big ego outside somewhere, and you'll do very well. The technique every time is to first think of the answer you want. You want the witness to say he was driving in Nelson Mandela Drive. Okay, that's the answer you want. Mr. X, where were you on such and such a date at 10 o'clock? You'll say, I was driving my car in Nelson Mandela Street. You see, that's quite simple. Now, many lawyers make the mistake of leading a witness in chief without first setting the scene. It becomes really quite stupid when you immediately, let's say it's an accident case, and you immediately ask the witness, where were you on such and such a date? I was driving in Nelson Mandela Drive. Tell the court what happened. Now that's terrible. You've got no control of the witness. The witness will just talk and ramble on, will get irrelevant, will irritate the judge. You've lost control. So what you do first is you set the scene. And how do you do that? you're setting the scene not for the benefit of the witness, but for the benefit of the judge. So the judge understands the evidence. Present the judge with some visual evidence, like a photograph, or a map, or a diagram, or a satellite a photo from Google Earth that shows where this scene occurred. Now that the judge and the witness is familiar with the scene, now go to the details. In what direction were you driving? And so on. Now, there is a method in avoiding the leading question. You must use what we call the headlining method and asking transitional questions. What you do is, with the headlining method, first tell the witness what they can expect. So give them a headline. I'm going to ask you about your employment. Now, the witness knows what's coming. The judge knows what's coming. It's not a leading question. I now want you to apply your mind to the events that took place on Friday night. Now the witness knows what you want, and you ask the questions. The next technique is what we call looping or piggybacking on previous answers. So to avoid a leading question, you say, Mr. Smith, where were you on the 10th of July? I was in Nelson Mandela Drive. At what time were you in Nelson Mandela Drive? It was at 12 o'clock that day. What were you doing in Nelson Mandela Drive at 12 o'clock? I was walking to my place of employment and I stopped at the intersection to cross the road. While you were waiting at the intersection, what did you see? So you notice what I'm doing? I'm building the next question from the answer to the previous question. It's called piggybacking or looping. It works very well. You control the witness and you don't have to ask any leading questions. Perfectly, works perfectly. Always use a chronological sequence. Use diagrams, sketches, and photographs. Visual evidence is brilliant. You must use it. You want to be in control. Avoid multifaceted questions. Okay? Like, while you were in the intersection, where were you standing exactly? And what did you see? And from what direction did the other side's car come from? There's 4 questions there. Okay? That's confusing. Usually the witness will answer 1 or 2 of the 4, leave out the other 2. You might forget to repeat the question. Guess what happens in argument? Your opponent will say, my lord, the witness refused to answer that question. My learned friend pertinently asked that question. The witness evaded it. Do you see? It's just, you made the trouble, okay? Avoid open-ended questions like, what happened? What happened next? Tell the court what you saw, all right? They can be dangerous. You don't know what's going to come out. You must be confident in your witness. You must look confident in your witness. If you look like you're disappointed in your witness or you get antagonistic towards your own witness, well, it rubs off on the judge. The judge says, bad witness. His own lawyer doesn't believe him. Credibility of the witness. You have to establish this. So how do you do it? You must lead relevant background information. In other words, you must set the scene. Show that he has personal knowledge. How did he get personal knowledge? Set that up. The evidence will strengthen your witness. Show that he had an opportunity to observe, that he has knowledge of what he saw, that there's a lack of interest in the outcome. There's no bias, okay? And you must not be boring. Oh my gosh. Never lead your own witness in a boring monotone. Don't ever appear to be disinterested in your own witness. Listen, sometimes what the witness is saying is boring. Okay? Trials can't be exciting all the time. In fact, they are boring most of the time. But you're a trial lawyer. Trial lawyers have to be actors. You must learn how to look interested in someone who's boring you to death. Okay? Now, if you don't know how to act, I'm seriously suggesting that you take some drama classes. Otherwise, you're not going to be very good in court. Okay? You must hold the attention of the court. That is why I say maintain eye contact with the witness and then look at the judge. Okay? You also need to stop or pace the witness so that the judge can take notes. Okay? The witness says something crucial. You look tellingly at the judge. Okay? You have to keep the evidence relevant. Now, here's the problem. You can be eloquent and you can be a great actor, but if the facts that are coming out is actually irrelevant to the issue, a judge will stop you and say, hold on, why did you call this witness? Is there any point in this? When a judge says to you, is there any point in calling this witness? The judge is saying, why is this relevant? So the idea is that the witness must present evidence that is relevant to the issue before the judge. Okay? And, you must keep it interesting. Okay. Now I come to the next thing, cross-examination. Trust me, cross-examination is not about repeating the evidence in chief to the witness, but only in a loud voice. Okay, that's not cross-examination. That's being an idiot. Okay. The first rule of cross-examination, firstly, never ask a question if you don't know what the answer is. If you don't know, don't ask. The second rule, know when not to cross-examine. A good lawyer knows when not to cross-examine. Good cross-examination technique also includes when not to ask any questions. There are those witnesses, if you know that you've got no ammunition to go at them, then it's better to say no cross-examination, my lord, and sit down. But remember, you're a good actor. When you decide you're not asking any questions, you want to make as if this witness has been totally irrelevant and of no assistance, therefore you're not cross-examining. So you'll do something like this. You'll say, well, my lord, if that's the evidence in chief, I have no questions. Sit down and look fed up, like they wasted your time. Okay? That's how it's done. Don't ask questions for the sake of asking questions. That's not the purpose of cross-examination. Okay? The purpose of cross-examination is to bring out evidence from your opponent's witness that suits your case. That is why I say, if your opponent's witness did no damage to your case, no need to cross-examine. Sit down. Now, here are the purposes of cross-examination. Elicit facts favorable to your case. To challenge the truth and accuracy of the witness's version, its credibility. Discredit the witness. Introduce your client's case or give the witness an opportunity to comment. Now, if you're in a civil trial, you are not compelled to put your version to the witness. But if there's a serious conflict between the two versions, then you will have to put your client's version to the other side's witness to enable them to comment. In a criminal trial, obviously, it can be fatal if you did not put your client's version to the state witnesses. You want to undermine witnesses who are still to testify. What does that mean? Remember I told you, if your first witness goes well, don't call the next one. Because when you call the next one, you can cross-examine the second one and start introducing contradictions with the first witness. You can damage a witness who hasn't even testified yet. You've got a witness in the box, you'll say, Mr. Jones, Mr. Smith is outside. You saw him sitting there. Yes. He's going to testify here. Yes. He will say the following. I don't know. He will contradict what you just told us. You can't explain the contradiction. No. Do you see? You start damaging the witness by referring to what the other one is going to say. And cross-examination is a very good place to parade your own case. Okay. Now, here's some practical tips. If it's not necessary to cross-examine, don't. If the witness does not damage your case, don't cross-examine. If you don't have effective ammunition to cross-examine, don't cross-examine. If you do cross-examine, keep it short, sharp, and relevant. How it's done is you ask short leading questions. It's machine gun style, rat-a-tat-tat, sit down. That's it. Very effective. If you repeat the evidence in chief to the witness, you serve no purpose. Now, there's some lawyers who have this stupid idea that if you ask the witness to repeat the evidence in chief, they will make a mistake. And then you can latch onto it. It doesn't happen. Of course, a witness will make contradictions to what they said in chief, but they're not material contradictions. It will not be a change of version. There may be a difference in some detail. The judge will not find that to undermine credibility. In fact, the judge will say, it shows he's not rehearsed this. He's talking from personal knowledge. So he made a mistake there. I still think he's a credible witness. So you're not getting anywhere. So never repeat the evidence in chief. It's a complete waste of time. A good lawyer will make an assessment of the witness. You hear them in chief. You can see this is a good witness or a bad witness. You must always listen to the witness's answers. Never get into an argument with a witness during cross-examination. I'll tell you why. Because you always lose that argument. Now, I'll tell you what you should do. What causes arguments? Why do some lawyers start getting into an argument with a witness during cross-examination? First of all, it's not cross-examination if you're arguing with the witness. Why do they do it? There are some witnesses who know what to do. They will needle you. They will make comments to undermine you. A good lawyer ignores all of that, sticks to the job, puts leading questions, moves on to the next set of facts. The witness makes a snide remark. Oh, my lord, he never heard me mention. Perhaps he's got a bad memory or something. They'll insult you. Don't worry about it. I find that those lawyers who have a big ego, they get sucked into this and they end up discrediting themselves. Just leave it. You are never, one of the things that happens under cross-examination, if you don't stick to the technique of asking only leading questions, you will get an answer that you are not expecting. You lost control and you'll be caught by an answer that you did not expect, and it's going to undermine your case. The one thing you never do, I told you there's some acting involved. When you hear the wrong answer, you quietly move on to the next question, like that's just what you wanted to hear. If you look like if you look shocked, or you look up into the ceiling, or you show frustration, or you say, that's not what I asked you, the judge can see you just got nailed. Your opponent will be writing notes to be used against you in argument. So look cool, look like that's just the answer you want, and just quietly move on. Okay. You must never badger a witness. I showed you the purposes of cross-examination. I did not tell you that the purpose of cross-examination is to break the witness. That only happens in the movies, in courtroom dramas, where the witness is reduced to a quivering heap and is then carried out of court on a stretcher. That never happens in a real trial. If you get nasty, you are rude to the witness, you will get the judge against you. Guaranteed. Judges hate it when the lawyers are rude to a witness. The lawyers are in a position of authority. You're standing there in robes. You look like an important person, and you start being rude to the witness. The witnesses don't like it. They feel undermined. They feel that you are damaging their dignity, and it's just the wrong thing to do. So never badger a witness. And remember, there's no such thing as breaking a witness in reality. You are not to breach the rules of evidence. Now, there's an important rule of evidence when it comes to cross-examination, and never, and I mean never, ever break that rule, because it is unethical. Never confront a witness in cross-examination with a fact or a submission that you know is not true. The witness testified that the robots were not working. It's common cause that that day the robots were definitely not working. Evidence has been laid. Now you say to the witness, on that day the robots were working. And the witness says, no, it was not working. I put it to you that the city engineer will say that the robots were not working. You don't have a city engineer coming to say that. Now, if you do something like that, you are misleading the witness, but worse, you are misleading the court. If you go and look at the code of ethics for legal practitioners, you will see it there. And if you do that in court, the judge will stop listening to you. And as soon as there's an adjournment, the judge will be reporting you to the LPC. That's what will happen. So don't do it. I told you, never ask if you don't know. Ask only leading questions. This is what you do in your questions. Bring out facts. Okay? It was raining on that day. Yes. The roads were slippery. Yes. You saw the defendant's car slide along the tarmac. Yes. Now you know those things are true. Those you are putting the questions, you know that you know the answer. One fact per question, okay? Don't ask multiple questions in cross-examination. Use simple words, small words, simple sentences. Always think before you ask. Always know the answer. Then put the leading question. You must be precise in your language. If you use plain language, you'll be okay. One of the things you don't do is ask your opponent's witness for an explanation. Why do you think the collision took place? I mean, do you know what the answer to that is? You don't want to know what this witness thinks. You don't want an explanation from the witness, okay? Now, here are some words that you can use at the beginning of a sentence that will help you to avoid leading asking non-leading questions. How, what, when, why, describe. Explain is the one question you don't ask, okay? You can ask if you know the answer. Explain what was the make and model of the car. Or explain what happened just before the first floor crashed. It's something like that. And here's the rule. Think of the answer, then put the leading question. Simple as that. By the way, the correct technique is think of the answer, ask the leading question. It's easier said than done. You'll only get that right with practice. You must do it in court. Get on your feet and use the technique. Now, although the presiding officer will usually give you ample opportunity to cross-examine, there are certain things they don't like and they will stop you. And when a judge intervenes to stop you, the judge stops taking you seriously. You'll damage your own performance in court. Vexatious, abusive, oppressive, discourteous examination must be avoided. Don't be sarcastic with the witness. Never be rude. That's a sure way of turning the judge against you. What's wrong with being courteous? This is your opponent's witness, I know. But remember, we're not there to use an adversarial approach. We want to be polite to the witness. We want to treat them like the human beings that they are, and we want to bring out the facts that suit us. Aggressive cross-examination is not the most effective. That only works in courtroom dramas on television, okay? You know, if you stand up in court and you badger a witness, you are rude to them. You indulge in aggressive cross-examination. You know what? Those people sitting in the gallery, they'll be impressed. They'll say, wow, this is a hot lawyer. Hey, he's just like on TV. Guess what? The judge is not impressed. Not at all. And when you lose the case, your fans in the gallery will be wondering, oh, what went wrong? I mean, he destroyed the witness. That's not why you cross-examine. You don't cross-examine to destroy the witness. Just bring out the facts. Undermine the bad facts, bring out the good facts. And then there's the point I was telling you about misleading the witness. Misleading statement will damage your case, and it is unethical. Just don't do it. Never ask questions that are irrelevant. Your questions must be relevant to the issue or the credibility of the witness. You must have seen this in court where a line of questions is used and the judge says, what's the relevance? You say, my lord, it goes to credibility. The judge will allow it up to a point, okay? You are allowed to repeat questions to test the witness, but must be limited. If you do this excessively, the judge will intervene or your opponent will just stand up and say, objection asked and answered, and you look like an idiot. The cross-examiner is not allowed to elicit inadmissible evidence in his favor. A witness cannot be cross-examined on a privileged statement, so just beware of that. If you ask questions about a collateral issue, the answer you get is final. You're not allowed to launch into an inquiry. Why is that the case? Because if you elicit an answer on a collateral issue, in other words, the issue is, it's not an issue that the court has to decide. It's a collateral issue. It came up. If you are now, if you are allowed to now cross-examine on it and call witnesses to rebut, the trial will never finish. Trials will run forever. And be careful. If you elicit unfavorable evidence in a legitimate answer to your question, you cannot object and it is admissible. That's another reason why we say, do not ask a question if you don't know the answer. Simple as that. And here's some final suggestions. Cross-examine only if the evidence is adverse to your case. Do not cross-examine if it's not necessary. And you must plan your cross-examination. How do you plan it? You look at the material facts that this witness gave the court. Mark off those facts that are against you. Now you know that you have to undermine those facts. Ask questions to undermine only those facts. And when you achieve what you want, sit down. And then don't allow yourself to be deviated by anyone. That includes the judge and your opponent. You know, one of the things, the oldest trick in the book, and you shouldn't fall for it. If you are cross-examining the witness, you are putting one leading question after another and you're getting the answers you want. Your opponent can see this is going down for them. So your opponent will say, objection, my lord. Yes, what's the objection? And it's a spurious objection. They put in an objection just to throw you off your line of question and to disturb you, to distract you. You know what? Don't tolerate it. When an opponent does that to you, look at the judge with disgust on your face and say, my lord, that was a spurious objection calculated to protect this witness. Your lordship will see through it, and I intend to continue on this line of questioning. The judge will know that this was just a distraction and will probably give your opponent a withering look, and that would be enough of a warning to your opponent not to do it again. Now, this point I'm coming to now is one of the worst mistakes lawyers make. It's one of the most common mistakes lawyers make. Never attempt to get concessions the witness is not likely to make. Don't do it. So let's take an example. The opposite driver stated in his evidence in chief that he was driving at 60 or a little less. Now you know that your case is that he was speeding. So now you cross-examine, you do this. Mr. X, you were driving along Nelson Mandela Drive. Yes. It's in the middle of Benoni. Yes. It is in the city. Yes. The speed limit is 60. Yes. You are approaching the intersection. Yes. It is a robot-controlled intersection. Yes. You told the court that it was green for you. Yes, it was green for me. As you entered the intersection, you applied brakes. Yes, I had to. You left a skid mark of 25 meters on the tarmac. You don't dispute that. No. Now, a good cross-examiner stops right there. Bad cross-examiner will ask the next question. You were speeding at the time. No, I was not. You could not have left a skid mark of 25 meters if you are not speeding. I disagree. My car skidded, even though I was doing a little less than 60. Do you see what happened? You damaged your whole cross-examination. You see, when a witness says, I was going at 60, you are not going to get them to concede that they were speeding. The witness won't say, oh, you caught me. You got me. I was actually doing more than 60. I'm terribly sorry. That's not going to happen. Okay? Again, that nonsense happens in the TV dramas. If a witness testifies that he saw your client on the scene, you can damage his opportunity to observe, and then you must sit down. Don't say to him, oh, but you could have been mistaken. He's going to say, no, I know it was him. I saw him. You damaged it. You damaged your whole cross-examination. There's a difference between obtaining a concession and obtaining the facts to present argument. What you do is you obtain the facts so that you can argue that the witness was speeding. You don't need the witness to concede that he was speeding. That's what the judge has to determine. It's one of the material facts you're relying on to prove negligence. You don't have to get that from the witness. All you have to do is tell the judge, these are the facts. The only reasonable conclusion to be drawn is that the witness was driving well over 60. It is not probable that a skid mark of that magnitude can be applied at under 60 kilometers an hour. That's persuasive, okay? Don't damage it. Your conclusions and comments happen in final argument. Never expect the witness to agree with you. They will not. They're against you. All you do is get the facts to enable you to argue. So, how you lead your own witness in chief and how you cross-examine your opponent's witness will determine if you are persuading the judge. If you make a hash of this, you lose the case. Okay. Now, we're getting to experts. I have dealt with this in some detail already. I've dealt with the joint minutes and the case management of this. It's a very good idea that if you are going to use an expert, you tell the judge about that in opening statement. Always tell the judge in your opening statement that I will be calling Dr. Jones. He is an orthopedic surgeon. He is my expert witness. Your lordship will have seen the summary and the joint minutes of the experts. I will lead the witness only on a narrow issue, and it is this. That's what you do in opening statement, okay? When you lead in chief, confine your witness to that issue. And again, no leading questions. You will be allowed to lead where the parties agreed on the expert's evidence. As long as there's agreement, you can ask leading questions, not a problem. In fact, leading questions in those circumstances are actually welcomed by the judge because they save time. Under cross-examination, you have to be very careful. This is an expert. This expert knows a lot about his discipline. In fact, he knows a whole lot more than you do. Now, you must have heard this nonsense that in order to successfully cross-examine an expert, you have to become an expert yourself. Well, that's overstating it. You can never be the equivalent of someone who spent 10 years or more studying the discipline. I mean, you've got an LLB. I mean, that's all you've got. But that doesn't mean that you shouldn't read up on the area. Read a basic textbook. Look at what the judgments say about this type of evidence. That's what you do. But the very important thing about cross-examination is that you must consult your own witness first before you cross-examine. You would have done this in preparation. Okay. If it is a very complex matter, like an aircraft crash or something, or someone became a paraplegic after an operation, then I suggest that when the opposite expert is testifying in chief, you must have your own expert in court sitting next to you. That expert will then guide you as to where you should attack the other one's um, uh, evidence. Now, in a foundational attack, your cross-examination should exploit the following areas. Now, I told you the opposing experts' investigation of the case at hand. Now, there are some things you shouldn't waste your time with cross-examining. Things like qualifications, experience, and so on. Unless this is some dodgy expert that they went and dredged out from somewhere, then you can go on an attack. But mostly when you're dealing with scientists and doctors and actuaries and so on, these are very credible, highly qualified people. Don't waste your time tackling them on their qualifications and on their knowledge of the subject, because they are the experts, not you. You concentrate on the opposing expert's investigation of the case. Now, what happens in investigating a case? The expert is looking for facts. You've got to look at the expert's methodology and the expert's conclusions. What facts did he have? What method did he use to analyze? What is the conclusion? Now, you will need your own expert to advise you on this. These are the areas you can cross-examine. Now, there's a guide here to cross-examining the expert. I said, research the subject matter, become an expert. That's an overstatement. Don't believe it. But you must read up something. You need to know the basics. And I'll tell you why it's so important to know the basics. Because you'll get familiar with the language of the expert. So they will use jargon. All experts use jargon. It's unavoidable. You will understand the jargon. You will not constantly ask for an explanation. In fact, you will impress the judge by giving the judge the explanation of the jargon. The judge will say, thank you, and you'll carry on. So at least be familiar with the terminology and the language of the expert. Look at the credentials, but I told you this can be a waste of time. Always consult your own expert with the same set of facts that the other expert had. Check with your own expert. Can these facts be used to undermine the other side's expert? At the beginning of cross-examination, always try to obtain favorable concessions from the other side's experts. You always know the answer, and you see, where the experts agree, you can use that in cross-examination. And you say, this is what our expert found. You agree with that. You don't dispute it. You accept that Professor Jones is an eminent scientist. Yes. He is respected in the scientific community. Yes. He has won many awards. Yes. You see, you can do that, and it's very effective. So you're using, and that's the point, you're using their expert to affirm your expert. Bring out areas that they agree on, but be careful, don't overdo it, because the areas of agreement should be in the joint minutes. Judge would have read it. Experts often have a problem with independence and impartiality, and also bias. I'll tell you the one expert that I never took seriously are psychologists. These are people, it's not an exact science. And I found that as long as you're paying, they'll come to the conclusion you want. I very rarely sat in family law matters, okay? I hate family law because everybody lies. So one of the things they did, the rich people here in Johannesburg, the dispute over the children. Mother goes to a psychologist and gets a report about what a wonderful mother she is. Father goes to a psychologist, gets a report of what a fantastic father he is. And so it goes on. Eventually, they file reports that are like 2 lever arch files full. It is just an abuse. Judges don't read it. They make their own assessment, okay? Don't ever do that. Don't bomb the other side with expert reports. They are unnecessary. Only get an expert on a relevant point. Keep it short, keep it simple. No lengthy reports, okay? Procedure and protocol is very important, especially with the sciences. You know, if you read up, you'll find that there are certain protocols that they have to observe in terms of methodology and research and their findings and their assessments. Ask your own expert about the procedure used by the other side. The source of information the expert received is very important. Remember, an expert very often gets instructions, like you get instructions as a lawyer. The instructions come from the client, and often it's a combination of the client and the attorney who will tell the expert, these are the facts. Now give us an opinion. Well, that's where it can go wrong. You know, if you want to cross-examine an expert, I told you, leave him alone when it comes to the qualifications and so on. Go and look at the facts that the expert received. And good experts will immediately concede that their opinion will change if the facts have changed. And that's how you tackle that. You must know who presented the expert with the facts. Where it becomes difficult is where the expert himself or herself went out and obtained the facts through their own investigation. And here's the point. Test the witness by varying the facts. A good expert will readily make the concession. A bad one will say no, but, and start waffling. Not impressive. And very often, the expert's opinion is based on facts established by other witnesses. So what you're going to do is you challenge the factual underpinnings by cross-examining it. And here's the point that you need to know. If you challenge an opinion, you must not only know that it is wrong, you must be able to show why it is wrong. Otherwise, the judge won't be persuaded. And remember, an expert witness is not a factual witness. An expert witness is an opinion witness. This is an expert who is presenting the judge with an opinion to assist the judge in an area where the judge does not have his own expertise. The judge can reject the opinion. It's not a factual finding. The judge either accepts the opinion or part of it or rejects it, or rejects a part of it. Your job is to get the judge to accept your expert and not the other side. And like all cross-examination, you must know when to stop. When you got what you want, sit down. Okay. And now we come to the final argument. The first rule you must hand over to the judge the following documents: a set of concise heads of argument. And I mean concise. Don't say to the judge, may I hand up my heads, my lord? And you give the judge 60 pages. The judge is just going to look at you and say, what the hell is this? Okay. A chronology document for the argument. Now remember, this is a trial. It's not an application. It's not an appeal. It's a trial. The judge is steeped in the matter. He's heard all the evidence. He's heard the witnesses. So don't waste time telling the judge what the case is about. Your job is to persuade that the judge that your case must succeed. You persuade the judge that your case must succeed, that you discharge the onus. The argument must be short. Lengthy argument does not work. This is what the judge wants to know when you stand up. What are the issues? How do you want the judge to decide the issues? And what remedy you want? Now, this is the classic method. How it works is you first tell the judge, this is the issue. This is the question that you have to answer. Now tell the judge the answer that you want the judge to make. So you give him your answer. Step 3. Now tell the judge the main points that you are going to rely on for that answer. Step 4, you take the judge point by point and you present argument. Argument means justifying your submissions with the reference to the facts and the law. Now, let me get one thing straight. Judges do not want you to burden them with case law after case law after case law. You know, for every legal proposition that you make, you can find at least 20 to 30 cases. You are not expected to cite all of them. The judge is not going to read it. What is the rule? And you will find this in the practice directives, in the SCA and the Constitutional Court. What the judge wants is the most recent decision of the highest court. That's it. In fact, in the SCA, they tell you that if you want to cite more than one case on the same point, you must say why. If you don't, you may be disallowed the costs of that. The other thing judges do not want to see is you copying and pasting from judgments. It's of no assistance to the judge. The judge can read the case for himself. He doesn't need you to copy and paste in your heads. What the judge wants is for you to make the point you want from that judgment in your own words and give the judge the reference to the judgment, which paragraph you are referring to. So also at the start, you also tell the judge what remedy you want. Okay. Now here's a very useful trick. Very useful. When you prepare heads of argument, also prepare a draft order, which you attach to your heads, where you'll say in remedy that the applicant, or the plaintiff rather, will seek an order in terms of the draft. Judges like that. They like seeing a draft. It means they don't have to sit down and craft an order for you. They might, if you succeed, you'll get that order, or you will get an order, the same draft, but the judge might make some amendments. Okay, draft orders work brilliantly. You must keep your argument clear, short, relevant, logical, okay? Judges do not need you to tell them what the law is. That's not what they want. You know, most judges, as soon as they're appointed, they somehow know all the law. It's miraculous. Some of them have never been in a courtroom before. Now, just appoint them as judges and suddenly they know all the law. Well, just remember one thing. What you want is to give the judge the one case, the most recent decision of the highest court. The highest court, obviously, is the Constitutional Court, the apex court. Next in line is the SCA. After the SCA, full bench decision of the provincial division. After that, it's the decision of the division where you brought the case, in the quota quo. And then below that are single bench decisions of other judges. Those may not be binding, but they will be persuasive. The higher the court, the more likely it is to be binding on the judge. So that's the rule. Stick to it. Judges are interested in the findings of fact and your application of the law. They want to see your reasoning. They don't want you to say, this is the case, and then copy and paste. That's not argument. Now, here's the process of thinking. Absorb the facts first. Now, remember, by this time, your facts have become even more limited because many admissions have come and gone. Many issues have fallen by the wayside. It's now more limited. What valid inferences can be drawn from the facts? Now, that's what we do. When we talk about findings of fact, it's not enough to say, I find that the defendant was speeding. That it doesn't stop there. What the lawyers want is now to draw inferences. Because he was speeding, he was unable to stop in time, and that caused the collision. You see, you're drawing an inference from a finding of fact. That goes into your heads of argument. When you've made the finding of fact and you drew the inferences you want, now look at the applicable law. What does the law say is the test? What are the material facts that you have to prove? Then make submissions as why you discharge the onus and you discharge the onus, then that you should win. Witnesses present the facts. Your job is to present comment, and your job is to draw the inferences. Never expect the witness to give you the comment, nor do you expect a witness to draw the right inferences for you. If you invite a witness to draw an inference, you are treading on thin ice. The witness might come up with an inference that you did not want, and it'll damage your case. Now, what I've done, I've given you a short method of how to lay out heads of argument, okay? You can read it. My book on drafting skills will tell you how to draft heads. I suggest you go and look at it, okay? All right, I'm going to stop there now. It's been quite an intensive session, this. I would like you this weekend, with load shedding, there's not much you can do, but you can sit down in some natural light and read this manual that Betty sent you. It'll consolidate all the concepts in your mind. That's the first step. The second step is commit yourself to practicing the technique. If you don't practice the technique, you will do what many lawyers do. They revert to their old bad habits and they stay there. They know it's wrong, but they're so comfortable with it. They got away with it. They make a living out of it. They carry on. The point I want to get at is that the legal profession now has been completely transformed from what it was when I was a young lawyer. Now, the competition is immense. I told you we're competing with people outside the profession, but the profession itself is overpopulated. The country does not have enough work to sustain so many lawyers, especially with a depressed economy like we have. However, and this might come as a surprise to you, we have a shortage of good lawyers in this country. We have an oversupply of bad lawyers. There is still room for you to absolutely thrive and reach the top of your profession if you are a good lawyer. People are looking for really good lawyers. There are so many bad lawyers out there. Nobody wants them. But the law firms, commerce, is looking for good lawyers. You can only become a good lawyer if you apply the techniques, if you practice the techniques, and you just have to be hardworking. And also, you have to read one book a month. You have to maintain your skills, your literacy skills. That's what makes a good lawyer. So commit yourself to being the best you can be. Otherwise, you just wasted your life. If you are going to be a mediocre lawyer, that's fine. You can be mediocre. You'll survive. But eventually, I can guarantee you, the pressures will get to you and you'll start drinking. That's what's going to happen. You'll just start drinking. So don't end up there. I've seen too many of my colleagues do that. Betty, are there questions that came through?
Yes, sir. There was two. There were
Oh,
two.
is it on the email?
It's on your email, and then there's another one just arriving.
Okay, I'm going to go there now. Okay, I've got it. Okay, Mr. Kuzwayo, I just want to ask whether is it correct for the opponent to ask you to discover what you cited in your particulars of claim instead of waiting for discovery stage? Oh, the answer to this is in the rules. You don't have to wait for discovery. There's a rule that says that for purposes of pleadings and for preparing yourself, you can request discovery. Just go and check the rules. You don't have to wait for the discovery stage, okay? Another question. Okay. Kitma, how many pages of heads are considered not concise? Well, there's a standard by which you can measure this. Go and look at the rules in the SCA. In the SCA, the Constitutional Court and the Gauteng Local Division have set page limitations on heads. Firstly, the heads must be done on one side of the page, double spacing, and must be confined to 40 pages or less. If you want to go more than 40 pages, you have to write to the judge president and get permission. Okay. In the Constitutional Court, they don't have heads of argument, they have written argument, but again, it's confined to 50 pages. Okay. So, and just get one thing straight. If you need more than 40 pages, if you can't make your point in 40 pages, you are not going to make it in 50 or 60. Okay. Don't give unnecessary reading to judges. They hate it. So if you're in the High Court, your maximum is 40, but try and keep it to much less than that. I say 20 pages. You know what the problem is? It's much easier to write long heads. It is more difficult to write short ones. The reason it's difficult because you have to really think apply your mind before you can come up with short heads. That is why short heads are so effective, is because you did your job. Long heads, anyone can write long, baggy heads, 60 pages, 70 pages. They're useless, okay? You will not be allowed to file that many pages in the SCA, in the Constitutional Court, and here in the Gauteng local division. They don't expect more than 40 pages. Okay. Is there another question, Betty? Okay, I've got it.
Yes, sir.
Okay, I've got them. If Rule 41A is important, this is Kitima. Why is it that when non-compliance with the rule is raised as a point in limine, most judges do not even consider it? I've done it a few times, and it was even and not even commented. It is as if it is not considered important and just raised for the sake of completeness. What is the best way to raise in more punchy way? Yeah, I understand your question. Remember, 41A is a new development. Currently, if you went to court and said to the judge, the other side have not complied with 41A, you do this in limine. Well, the judge is not going to be interested. As you correctly say, they're not even going to comment. In fact, if there is a comment, the judge will say, do you have a better point than that? You see what judges want to do? The judges, this is a matter that's before them, it's ready for trial. They want to decide the matter on its merits. The fact that a process like 41A was not followed is not a train smash. It's not a process which non-suits either of the parties. That is why they will not take it seriously. Now, if you want to add some punch, what you should do is set it up. You can't complain about your opponent if you didn't take it seriously. You must have filed all the notices. They will be in the court file. You will show that your opponent did not cooperate. And you can then say in your opening statement, my lord, this is what happened in Rule 41A. There was no compliance by my learned friend. I will address this to your lordship in order to make an appropriate cost order. Now the judge will listen to you. So we're going to leave it to the end, okay, for argument, where you will then take the judge through the papers, show that you have complied with 41A. The other side never bothered. The judge will take that into account in a cost order. Okay. Right. Another one. Can you comment on practice directives, please, and how they relate to the rules? They do not replace the rules. The uniform rules are alive and well, and they apply. Directives are peculiar requirements of that division. It applies only in that court. They are published by the judge president or the deputy judge president, and you are expected to comply. If you don't comply, you get into trouble. That is why at the beginning of this course, I mentioned the practice directives, and you must read them and comply with them. Okay. The other thing is, in a province like this one, Gauteng, between the two courts, they keep changing the directives. You get new directives coming out almost on a weekly basis. What I want to say to you is you have to keep up with it. They are published. You can find them on the website of the court. You can find them on the LPC's website. You can find it on your local LPC branch website. The bars have it on their website. So access is not a problem. You have to keep up with it. The real problem with practice directives is that there's no uniformity. I mean, between Joburg and Pretoria, the practices are different. So it's a bit onerous for lawyers to keep up with it, but you have to. In other provinces, like take the Eastern Cape, they really can't be bothered with directives. So they're very few. They may just a couple of pages. It's not a problem because they don't see the need for case management. If you go to the Northern Cape Division, Kimberley, I don't think they have any directives. I haven't seen any. Northwest, nothing. If you go to Limpopo, they just uh, uh, took the Pretoria one and made it their own. They just bolus just copied it and made it their own. But that's the lawyers. The problem is that our uniform rules have become outdated. They just have not kept up. The rules board is quite useless. Our uniform rules need refreshing. We need to review it and rewrite it. So the judges got fed up of waiting, and so they come up with the directives to regulate their own processes. So remember, judges have inherent powers. They are not bound by process and procedure. They can determine their own processes and procedures, and that's where the directives come from. Okay. Any more questions, Betty?
I think there's one more, sir.
Right, I got it. I've got it. Two more.
Only one.
Oh, only one. Yes, you repeated the other one. Okay, from Doe, can the defendant serve his plea after the pleadings has been closed and the court date applied on an unopposed roll before the labor court? Oh, you can always file a plea late, but you're not free to do so. You have to bring an application for condonation. And I can tell you, judges are very keen, or rather reluctant, to refuse condonation. You have to explain why the delay took place, and sort of any explanation will do, provided that you can show that you've got a case and that's in the interest of justice to allow you to file the plea. So it's not a train smash if the time passed and your opponent went and set this thing down on the unopposed roll. You can still bring a notice of motion for condonation. And please remember, attached to your founding affidavit in the condonation application, you must have a copy of your plea. Okay. Candice? Okay. Thank you, Candice. She's just saying she enjoyed the presentation. Okay, thank you very much. I think that does it, Betty.
Thank you so much, Judge Hussain.
Good. All right. Thank you for attending, and I hope I made a difference to your career path. Okay. Thank you and goodbye.